Kentucky's approach to rent increases is shaped by the same dual framework we've discussed in our other Kentucky videos. The Uniform Residential Landlord and Tenant Act applies in some jurisdictions but not others, creating a split system where the rules depend on where your property is located. The URLTA is found in Kentucky Revised Statutes, Chapter 383, and understanding whether it applies to your property is the first step in handling rent increases correctly. As we've covered previously, the Kentucky URLTA only applies in counties containing a city of the first class or a consolidated local government, which means Louisville and Jefferson County, and any other county or city that has adopted it by local ordinance. For properties outside these jurisdictions, the landlord-tenant relationship is governed by common law, general contract principles, and the terms of the lease. Regardless of which framework applies, Kentucky does not have rent control or rent stabilization of any kind. There is no state statute that caps rent increases, limits the frequency of increases, or requires landlords to obtain government approval before raising rent. Kentucky's political and regulatory environment favors property rights and market-based pricing, and rent control has not gained meaningful legislative traction. Kentucky has not enacted a specific preemption statute prohibiting local rent control, but no Kentucky municipality has enacted or seriously considered local rent restrictions. Louisville, Lexington, Covington, Bowling Green, and every other Kentucky community operate under the same market-based approach. Given the state's political climate, local rent control is extremely unlikely. Now let's walk through the notice requirements under both frameworks because they differ. In URLTA jurisdictions, primarily Louisville and Jefferson County, the landlord must provide advance written notice before a rent increase takes effect on a month-to-month tenancy. The URLTA requires at least 30 days written notice before changes to the terms of a monthly tenancy. So, if rent is due on the 1st and you want the increase to take effect on May 1st, you need to deliver the notice by April 1st at the latest. The notice should be in writing, should clearly state the current rent, the new rent amount, and the effective date. Under the URLTA, the notice should be delivered by one of the authorized methods: personal delivery, leaving a copy at the tenant's usual place of residence, or sending by mail. In non-URLTA jurisdictions, which covers the majority of Kentucky's geography, the notice requirements are less precisely defined by statute. The general common law rule is that the landlord must provide notice equal to one rental period before changing the terms of a periodic tenancy. For a monthly tenancy, this means at least one full month's notice. However, because this isn't codified with the same specificity as in URLTA areas, the lease itself plays an even more important role in defining the notice requirements. For fixed-term leases in both URLTA and non-URLTA jurisdictions, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent. When the lease approaches expiration, the landlord should communicate the proposed new rate well in advance to give the tenant time to decide whether to renew. If the tenant doesn't agree to the new rate, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 30-day notice requirement in URLTA jurisdictions or the 1-month common law standard in non-URLTA areas. For week-to-week tenancies, the notice period for rent changes is 7 days in URLTA jurisdictions and 1 rental period, also 7 days, under common law principles in non-URLTA areas. Now let's cover the restrictions that apply regardless of which framework governs. Rent increases cannot be retaliatory. In URLTA jurisdictions, Kentucky has a specific anti-retaliation provision under Section 383.705 that prohibits landlords from raising rent in retaliation for a tenant exercising their legal rights. Protected activities include making a good faith complaint about habitability to the landlord or a government agency, reporting a code violation, exercising any right under the URLTA, and participating in a tenants organization. The URLTA's anti-retaliation provision provides that if a landlord takes adverse action after a tenant's protected activity, the tenant can raise retaliation as a defense. Courts evaluate the timing, magnitude, and circumstances of the increase when assessing whether retaliation occurred. A rent increase shortly after a tenant's complaint, particularly one that is significantly larger than the landlord's typical increases, creates a strong inference of retaliatory intent. In non-URLTA jurisdictions, the anti-retaliation protections are less formally defined and depend on common law principles. Courts in these areas recognize that landlords cannot use rent increases as punishment for tenants exercising their legal rights, but the tenant bears a heavier burden of proving retaliatory intent without the framework of a specific statute. Documentation and circumstantial evidence become more important in these jurisdictions. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Kentucky Civil Rights Act, found in KRS Chapter 344, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. The Kentucky Commission on Human Rights investigates fair housing complaints and can take enforcement action. Louisville and Lexington have enacted local human rights ordinances that provide broader protections than state law, including protections based on sexual orientation and gender identity. Landlords in these cities must comply with both state and local anti-discrimination requirements when implementing rent increases. A rent increase that targets tenants based on any protected characteristic, including locally protected categories, can result in a complaint and significant liability. Lexington has also enacted a source of income protection that prevents landlords from discriminating against tenants based on their use of housing choice vouchers or other lawful sources of income. This means Lexington landlords cannot raise rent specifically to push out voucher recipients while keeping rates stable for other comparable tenants. From a practical standpoint, Kentucky's rental market is anchored by two major metropolitan areas, Louisville and Lexington, with distinct secondary markets across the state. Louisville is Kentucky's largest city and most active rental market. The city's economy is driven by healthcare, including Norton Healthcare, U of L Health, and Humana's corporate headquarters. Logistics: Louisville is home to the UPS Worldport Hub, bourbon tourism and distilling, manufacturing, and the University of Louisville. Louisville has experienced steady rent growth, and landlords in desirable neighborhoods like the Highlands, Nulu, Germantown, and Crescent Hill have strong pricing power. Louisville also has a growing focus on housing affordability and tenant protections. The consolidated Louisville Metro government has enacted various housing-related measures, and the conversation around tenant rights continues to evolve. While rent control hasn't been enacted, landlords in Louisville should stay informed about local policy developments. Lexington, home to the University of Kentucky and the center of the bluegrass horse country, has a strong rental market driven by the university, healthcare, including UK healthcare, technology, and the equine industry. Student housing near UK follows the academic calendar, with rent adjustments at the beginning of each lease cycle. The broader Lexington market is competitive, and landlords generally have moderate to strong pricing power. Northern Kentucky, including Covington, Newport, and Florence, benefits from proximity to Cincinnati and the greater Cincinnati economy. Many Northern Kentucky residents commute across the river to Ohio for employment, and the rental market reflects this cross-border dynamic. Rents in Northern Kentucky are generally lower than in Cincinnati, which is part of the region's appeal. The area has seen revitalization, particularly in Covington's Mainstrasse Village and Newport on the Levee area. Bowling Green, home to Western Kentucky University, has a rental market influenced by the university, automotive manufacturing, including the Corvette assembly plant, and a diverse immigrant and refugee community. The student housing market follows the academic calendar, while the broader market benefits from manufacturing employment. Fort Campbell, one of the largest military installations in the country, straddling the Kentucky-Tennessee border, creates substantial military rental demand in the Clarksville, Tennessee and Hopkinsville, Kentucky area. Fort Knox, home to the U.S. Bullion Depository and various Army operations, generates rental demand in the Radcliffe and Elizabethtown area. Military tenants' housing budgets are tied to BAH rates, and landlords near these installations should monitor annual BAH adjustments when planning rent increases. Eastern Kentucky, the Appalachian region, has softer rental markets with limited pricing power. Many Eastern Kentucky communities face economic challenges related to the decline of the coal industry, population outmigration, and limited economic diversification. Landlords in these areas need to be conservative about rent increases and focus on maintaining occupancy. However, some Eastern Kentucky communities near new economic developments, such as the planned Appalachian Regional Hospital expansions or broadband infrastructure investments, may see improving demand. One critical best practice for Kentucky landlords: know which framework applies to your property. If your property is in Louisville or Jefferson County, you're operating under the URLTA and its specific procedural requirements. If your property is in Lexington, check whether the city has adopted the URLTA, and either way, comply with Lexington's local human rights ordinance, including the source of income protection. If your property is in a non-URLTA jurisdiction, your lease is your most important document because the common law provides less specific guidance than the statute. Another best practice, for landlords who own properties in multiple Kentucky jurisdictions, maintain separate procedures for URLTA and non-URLTA areas. The notice requirements, anti-retaliation frameworks, and local anti-discrimination provisions differ between jurisdictions, and a one-size-fits-all approach can result in compliance failures. Use different lease templates and notice forms tailored to each jurisdiction's requirements. For landlords in university towns, Louisville, Lexington, Bowling Green, and others, understand the student housing cycle and time your increases accordingly. Students typically sign leases for the academic year, and the natural turnover point provides an opportunity to adjust rent. Competition among student housing providers is often intense, and pricing must reflect the local competitive landscape for student-appropriate housing. Kentucky also has specific requirements for manufactured home community lot rents that differ from standard residential tenancies. Landlords who own or manage manufactured home parks should verify the applicable requirements for lot rent increases, including any notice and procedural provisions specific to manufactured housing. For Kentucky landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority, typically the Louisville Metro Housing Authority in Louisville or the Lexington-Fayette Urban County Housing Authority in Lexington. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. In Lexington, where source of income protections exist, the interaction between voucher program rules and local anti-discrimination law adds an important compliance layer. Submit increase requests well in advance. Kentucky requires landlords in URLTA jurisdictions to return the security deposit within 30 days of the tenant vacating and providing a forwarding address, or within 60 days if the tenant doesn't provide a forwarding address. In non-URLTA areas, the return timeline is governed by common law and the lease terms. While these rules don't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. For the complete guide to Kentucky rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.